Hi, everyone. Good to see you all. We'll get started in just a minute. Can you
Hello.
all just give me a thumbs up if you can hear me? These are not my usual. Okay, great. Thanks. Okay, we'll go ahead and get started. Great to see you all. Thanks for coming out. I'm Jen White, and I'm the founder and executive director of Arise Immigration Services. We have a dual mission. We provide free legal representation to asylum seekers here in Pittsburgh and training and mentoring to advocates around the country as we work on our cases together. So tonight's chat about asylum law is a part of a larger series that we're doing because we're a part of a collaborative, a local collaborative that is doing pro bono representation. So this training series is designed to equip pro bono lawyers who are not immigration attorneys to take on these cases. So if you want to know more about that, shoot me an email. I'll connect you to who you need to know to get involved. But basically, in a nutshell, we're going to talk about asylum eligibility, bars to asylum, and some common scenarios that you're going to see. If you haven't been to our trainings before, they're informal. Feel free to stop me if you have a comment or a question. It's actually pretty hard to get training opportunities like this where you can chat things out. So that's what we want to provide. So just stop me if you have a question or a thought. Okay. Also, if you want a copy of the slides or a certificate of attendance, just shoot me an email and I'll get that to you. I'm going to open up the PowerPoint. And what I'm going to chat about is applicable in both a removal defense context and affirmative asylum. Yeah, so Joshua, just shoot me an email and I'll get those to you, the slides. So as we all know, removal defense is quite different procedurally than cases before USCIS, but the actual legal requirements that I'm going to be talking about apply in both situations. Okay. Now let me just open this up. Okay. Okay, so asylum law. Most of this presentation is broken down into chunks so that they're understandable chunks, but I am going to start with the statutory requirements here. So to qualify for asylum, you have to be in the US. So if you're tracking immigration changes, you know that the Supreme Court just ruled on this. That whole concept of being in the US is now more narrow than it was. You have to meet the definition of a refugee, and I'm going to read that in a second. And you cannot be subject to a bar. And there's lots of bars to asylum, and they can be pretty robust. So there's a lot of requirements for this. I'm going to read you this statutory definition of a refugee because it's confusing. We're going to break it down to make it understandable, but I think it's worth reading just because you have to satisfy all of this. So a refugee is any person who is outside any country of such person's nationality, or in the case of a person having no nationality, is outside any country in which such person last habitually resided and who is unable or unwilling to return to, and is unable or unwilling to avail himself or herself of the protection of that country because of persecution or a well-founded fear of persecution on account of race, religion, nationality, membership in a particular social group, or political opinion. So we've done this presentation a couple times. Maybe you've sat in on these before. Every single time I read a statute or a regulation in an immigration context, I think it's confusing, much like this is confusing. So we break it down. These are the primary elements you need to prove to succeed on an asylum case. So we'll go through each one and I'll give you a couple of examples. And again, the idea here is just to kind of give you a high level view. There are many granular requirements that we won't get into because our goal is to equip people to actually do work and advocate on behalf of asylum seekers. But just bear in mind that you could satisfy all of these and then still get denied because of some particular aspect of your client's case, but it helps to start with the big picture view. So past persecution, this is a threshold issue, meaning did the harm your client suffered in their country rise to the level of past persecution? So you really need to know the legal requirements, right? Like, how do you define persecution? Well, two thoughts for you. One, the BIA, which is the appellate body that decides immigration cases under the executive branch, it's an administrative agency. They have really restricted what persecution means over the course of the last year and a half. However, the circuit courts across the country, the federal circuit courts that are handling appeals, many of those circuits have much more liberal interpretations of what persecution is, how it's defined. So you really have to know the law in your circuit, like where your client's going to be interviewing for asylum. And of course, the BIA recent rulings, which try to restrict it. As we've talked about in a number of other trainings, it's the circuit precedent that trumps the BIA precedent, which for us is very good. So our clients are in the Fourth Circuit, or they interview in the Fourth Circuit, so that's the case law that applies. And we have a lot of great precedent with persecution. And sometimes the standard's not as high as you might think. So I'll give you an example. Years ago, I represented a young girl. She was 12 when I met her. And she was a drug runner in her country. So basically, she had been kidnapped from her home when she was about 9. She lived in extreme poverty in Guatemala. And then it was her uncle who kidnapped her, took her away, forced her to be a drug runner. So what's interesting about these cases is that you have to do so much digging factually to understand what you're going to be arguing. So this young girl, like if you would ask her, did you suffer harm in your country? She would say no. Like she would not give you anything because her perception was so different than what mine was, frankly, because she had just grown up with abuse and statutory persecution and other forms of harm, but it's all she knew. So there was a lot of digging that happened, and we discovered that she was forced against her will to live with her uncle. He would threaten her if she didn't go like harvest the drugs and then deliver them. So she didn't have any sort of autonomy. So this is where the Fourth Circuit precedent applied in her case. Serious threats, even if there's no physical harm, can constitute past persecution. And that was the case in her situation. Her uncle would threaten to kill her if she didn't do what he said. But apparently he never laid his hands on her. Yet we still have persecution according to that particular Fourth Circuit case. When someone has suffered injury to her person or freedom being key there, that is also persecution in the Fourth Circuit. However, what we need to have in the Fourth Circuit is something that goes beyond mere harassment. So what I gave you there is kind of like the floor. It has to be beyond mere harassment. Excuse me. But some of those standards that I just read might not be as high as we would traditionally think. So that young woman was granted asylum. So it really helps to know the standard so that you understand how you can argue the case. And sometimes cases are stronger than they might appear to be. Okay, so well-founded fear. This is forward-looking. So it's the same idea. It's persecution, right? But it has to happen in the future. The person fears it happening in the future. So one thing to keep in mind with these cases is that you really want to separate the elements. It's very easy to conflate them, especially when you're starting this work, because the stories are complicated. We're dealing with a ton of barriers as we do this work, but you have to distinguish what happened in the past from what happened in the client fears in the future. And so a reason why this could get muddied is, say your client just entered the country 2 months ago and they just were persecuted, like the government detained them because of their political opinion and they endured beating and torture when they were detained. Well, it's pretty obvious they're going to have a fear of returning to their country because this is so recent, but you need to ask follow-up questions like, is the same regime in power? Maybe there was just an election and the same people are not as powerful as they were 2 months ago when this happened. So you get the point that you really need to distinguish the elements to make sure you're satisfying all of them. So with well-founded fear of future persecution, there are a number of different requirements, but two big ones are objective fear and subjective fear. So objective just means that the fear needs to be reasonable, like a reasonable person would be fearful in that person's shoes. And subjective means that the person is actually fearful, like they're actually scared to go back to their country. Excuse me, I have a tick on my throat. So you need both of those things. And like we've talked about in many of our trainings, a lot of our clients are really brave and have built up defense mechanisms and coping skills. So they might not even come off as afraid, even if they fled horrendous harm in their countries. So these are things to be aware of as you're helping clients write their affidavits, prepare for testimony, etc. And, another word of encouragement, given that this work is so hard, is that the Supreme Court has set a fairly low standard for fear. It's only 11% or higher that you have to prove for a well-founded fear case, meaning that if your client has greater than 10% chance of persecution in the future, if they satisfy that, they've satisfied this element. So it's not as high as you might think. And that's coming from the highest court in the land. So that's great news. Also, if your client did not suffer past persecution, they can still succeed on an asylum case if they prove future fear. And that happens pretty frequently, like circumstances change, client got out just in time, but they still have a valid future fear, and that's why they could be eligible for asylum. So I'll give you an example of one of those. A fear-based claim is what we call them when there's no past persecution. So about 8 years ago, I represented a gentleman from Iraq, and he is Kurdish. So if you're familiar with the situation in Iraq, Kurds have a long history of subjugation and persecution and various forms of attacks from the government and other groups. So this young man, he was enrolled in a PhD program at the time, and his father had suffered some real persecution in their country because of his Kurdish identity. But the son, my client, it was mostly just sort of vague threats that he had suffered, nothing direct, no harm to his person or anything like that. But this young man was really brilliant in his explanation to me, his explanation of the history of the way his people were treated in his country. And we were able to get a phenomenal expert witness to write a report for his case. And so as we were prepping him for his interview, this was during Trump 1.0, he did not appear afraid at all. He was a very cerebral personality. And I think at the time he was probably struggling with some depression. That was very much the impression that I got. And so as we were prepping for the interview, some of you probably heard me tell the story. I told him, there's a subjective fear requirement. You don't seem afraid at all. What do you think is going to happen to you if you go back? So he would explain, well, I think I could be harmed, but statistically, yada, yada, yada. So it's interesting in those situations. Of course, I can't tell him you need to look afraid, right? I don't want to, one, tell a client how to feel, and two, coach a client into any sort of dishonesty. But at the same time, I'm required to explain the requirements for asylum. So I remember telling him, look, you're going to interview with someone who was probably born in the United States, probably has not experienced the level of threats that you have, is probably not super familiar with the conditions in your country. So you've got to explain it. And so we went to the interview, and this officer was lovely. Like I said, this was during Trump 1.0. We sat down in the interview room, and the officer said, look, I want you to know, I'm sure you've been watching the news. I'm here to help you. I want to help everyone who interviews for asylum. I want to be respectful. So don't keep in mind what you're hearing about the administration during this interview. And he was ultimately approved. But the point being that subjective fear requirement is important. And sometimes we have to help clients satisfy that, assuming it's honest, right? We never want to help anyone misrepresent the truth. But at the same time, we all know that human beings are really good at adapting to hard things. So I think it helps to hold those two ideas together in our minds at the same time. Okay, so that's past persecution and future fear. Now protected ground. So again, we're trying to keep these separate, right? It's really easy to merge the protected ground with the persecution, but you've got to separate it out. So the protected grounds, according to the statute, are race, religion, nationality, political opinion, or membership in a particular social group. Just one word of caution right now in this environment is that particular social group claims are generally harder to prove and succeed on than the other four protected grounds. This administration just really doesn't like catch-alls like that. That's kind of how they perceive the particular social group ground. So if you have the option to include one of the other four, you probably should. So as we've sort of been talking about the barriers that we experience in our cases, whether that's past trauma, language, education, just the modern stressors that our clients are dealing with living in America right now under this administration, there's a lot to get through. But it's our job to tease out the protected ground. So, for example, when we do an intake interview at Arise, I make sure that we have a protected ground before we would even agree to take the case. So that we understand just in general what our case theory will be. It's not always super clear at that point in time, but I need to make sure we understand that we're going to have a good argument to make on behalf of this client, because otherwise you shouldn't be filing. It's borderline unethical, and you could be putting your client at risk if you do, especially right now. So I think four of these are somewhat self-explanatory. The first four that we talked about, the race, religion, nationality, political opinion, there's some nuance there, but I think all of us sort of understand what those things are. The particular social groups, you have to be familiar with the case law to know which ones qualify, like which groups of people are vulnerable in certain societies so that they could qualify under this weird term, particular social group. And so that's where ideally you would look to the circuit case law as opposed to the BIA case law, because it tends to be better in general, at least right now, because of the very restrictive cases that are coming out of the BIA. So you've heard me talk about this before. Excuse me. The BIA basically stands firmly in the camp that families cannot constitute particular social groups, whereas in the Fourth Circuit, they're super clear. Families are particular social groups. They are like the quintessential particular social group. So those two things are at odds. Thankfully, Fourth Circuit wins out there. When thinking about protected grounds, a lot of times you're going to come across fact patterns that invoke a lot of different protected grounds. And so you might be wondering, well, how many should I argue? Does it dilute the claim if I argue 10 of them? Does it make it look like we're actually not arguing anything? Or maybe you have one that's really strong, but then you have a couple other ones and you're not really sure. This is something that I tend to fall back on a lot. Ask yourself the question, what does your client want to talk about? Like, what do they like to talk about? Which part of the story are they perhaps proud of? Like, for example, we represent a number of political activists. So a lot of them are proud of the work that they did, and they like to talk about that. Which aspects of their claim maybe do they not want to talk about because of trauma or some other, negative feelings that they have in reliving the story? So the idea here is that your client, of course, will testify. If they're in removal proceedings, they'll testify in a really stressful environment if they're lucky enough to get a trial nowadays. And if they are applying for affirmative asylum, they will interview for asylum at the office, which is less stressful than court, but still, of course, terrifying if your life is really on the line. So ask yourself the question, what will they talk about at the interview? And this is very important because we might go to a lot of effort to put together a robust filing with a great legal argument, and the officer never even reads the case. Like that's very much a possibility. They might just go off of what the client testifies to. And that's the portion of the case that we know is going to happen, like that we know the asylum officer is going to interface with your client's testimony. So we want that to be good, and we want to understand how the client's going to tell their story. So anyway, the idea is ask yourself the question, what will the client succeed in talking about? So years ago, again, during Trump 1.0, I was handed a case from another lawyer. We were at the same law firm at the time. This other lawyer had assembled the case, filed it, and then I was going to take it on for representation at the asylum office interview. So this young woman was from Venezuela. Her aunt was a well-known judge who was persecuted. And then she herself was a political activist. So she defined her political views, or the statutory political opinion, as pro-democracy, basically anti the powers of her country. And we had a couple other formulations of her political opinion. But she was very offended by her government's dishonesty about elections. So as I was prepping her for her case, the lead argument that the other attorney had prepared was a particular social group argument based on her relationship to her aunt. So a family-based particular social group. But as I was preparing her to testify at her interview, she loved to talk about her political views. And she told me these beautiful stories about how she would work on election days. Her government would place the polls at the top of buildings so that people who had disabilities or medical issues could not climb the stairs up and vote. And there were no elevators, of course. So this young little woman would carry people on her back up flights of stairs to vote. She was telling me this, and I was so moved. And so I said, do you have pictures of that? Like, how can we document that? And as you're talking to me, you sound great. I want you to be this passionate at the interview. And so she showed me these pictures of her shoes that she took after that day. They were all worn out. And so through that conversation, I said, oh, like when you're talking, I really think you should emphasize this, your political views. You can, of course, mention the particular social group based on her family with her aunt, but that's secondary. Like, talk about your opinions. It's inspiring, and it's like very on point with the statutory requirements. So that's what we did. She whipped out her pictures during the interview. It was actually really interesting to watch because her English was very good, but she brought her sister to interpret for her. So when she was calm, she would speak in English, but then she'd get really passionate and work up when she was talking about her political views, and she'd switch to Spanish, and her sister would kick in with interpreting. So anyway, the idea is like go with what your client wants to talk about and what they're good at talking about, because it really helps since they're the one that really has to prove it during the interview. Okay, nexus, next element. It's very easy to conflate nexus with protected ground because they're connected. But again, we want to separate it out. So I put this in red font because I think this is generally the hardest element to prove for most cases. So nexus means that the persecution that was either suffered in the past or is feared in the future must be because of a protected ground. So what you're doing is assessing the persecutor's motivation. The mind of the persecutor is what you're evaluating. A couple thoughts for you on this. A super common issue that we deal with is we will ask clients, say it's a political opinion case, we will ask clients, why were you targeted? A lot of clients will say they don't know, or they will say, well, I don't have evidence. I don't have anything in writing. I don't have any photos. It is perfectly acceptable to ask the client what they think happened, what their understanding of the persecutor's motive is. That is evidence in the form of testimony during the trial or during the interview. And so that's something we kind of have to encourage clients to get out. a lot of folks are reluctant to make guesses. And of course, again, we never want to help someone misrepresent anything, but at the same time, we have an ethical obligation to help our clients tell their stories. So there are some helpful questions you can ask. You can ask, why would you be targeted and someone instead of someone else? It's also helpful to know what happened immediately before any sort of attack, because that can help you piece together, like, okay, did you come home from the rally where you protested and then the police came to your door? The sequential connections there are very helpful. Also, if there are any warnings or threats, super helpful evidence for nexus. So you just want to make sure you separate the protected ground in your argument and even in your evidence presentation from the why or the because, which is nexus. Another challenge that we deal with is that many cases involve mixed motivations, because of course they do. Human beings have all kinds of motivations, and if someone is motivated enough to persecute another human, a lot of times it's not just like one particular trait they're going after. A lot of times it's multiple traits. So this goes back to the whole, well, how do we present the case in a way that's compelling and strong without diluting it with too many arguments? So I'll give you an example of one of the cases I worked that had mixed motivations from the persecutor. So again, another story from Trump 1.0. I represented a young man who was from Iraq again, and he was abducted by Shia militia when he was pretty young, like very early 20s. And so this young man was from a pretty well-to-do family. And he was also, he identified as Shia himself, but he also explained that he was pretty liberal in his religious views. So he would tell me, I am also Shia. Ironically, like the Shia militia that targeted and abducted me, but my views are very different. I'm progressive. I believe in education and I'm westernized. So it's very different. That's the way he explained it to me. So if you think about that, you can see like, okay, he was probably targeted because he was wealthy, because he was held for ransom. And that's ultimately how he was released. His father paid a lot of money. Maybe he was targeted also because of the religious chasm between himself and the other folks. Like he was viewed as like a liberal Muslim, and they identified as more conservative Muslims. And this is all coming from his explanation and what we were able to formulate. He was also very educated, and his like brand of education was very offensive to the Shia militia members who targeted him. So there's a lot going on there. And this is pretty common in the cases that we work. So what we did is we clearly identified these different vulnerabilities that he had based on his own religion, political views, and then we also formulated some particular social groups based on his status, like he was a part of a wealthy, progressive Shia family. So that was one of our particular social groups. So we did throw a lot out there in terms of our argumentation, but we kept it clean enough that they were these distinct groups. So the judge, it was very interesting at the end of the trial, he said, you know what, I view this as political, not religious. He said, I think that the tensions in the Middle East that are sort of exemplified in this case are political, they're not religious. Very interesting to me. People can view things through such different lenses, right? And he said, I'm going to grant this case based on the particular social group, educated, secularized Shia men. He just saw that as like a politically vulnerable group in this young man's society. So that's why he decided to grant the case. So the takeaway there is we don't know how the adjudicator will view the context. Human beings have such different ways of looking at facts and conflict. So it really helps to formulate your protected grounds in a way that casts a wide net, so that regardless of how your adjudicator looks at the case, they'll find something to land on to grant it, hopefully. Okay, so that was a lot of material. I'll pause. Comments, questions? Okay, I see one in the chat. What level of evidence is expected for an individual hearing? Okay, so that's a very hard question to answer. The best explanation I can give you is actually from an ALA study. This was done 10 or 15 years ago. And their estimate was for every asylum case that you file, about 100 hours worth of work go into preparing that filing. So we're going to go over this. Actually, I'll give you a little preview as part of this presentation, but we will talk about the different components of your actual filing, like what you're submitting to the government. So hopefully that'll give you more of an explanation on that. And then we are going to do a more in-depth talk on that in the coming weeks. I forget the actual date, but we're going to talk about the components of an asylum filing. Is testimony of the individual enough? So theoretically, yes. You can succeed on an asylum case by only filing the application, proving your identity, and giving good testimony. Like that's the legal floor, theoretically. In this environment, I don't think that that would hold up. I think you've got to file as much as you possibly can. The standards have become unbelievably high for a lot of different reasons. So I would plan to include everything we're going to talk about. Let's see, I think it's toward the end of this presentation. Yeah, I'll go over the different components. So you need to thoroughly file all of those different components, unfortunately. Do you need corroborating evidence? For instance, I have a client who is alleging the state took part in her persecution. Do we need corroborating evidence to prove that, or will the testimony be sufficient? Okay, so I'll just give you just a generalized opinion that I have. No, you should absolutely not bank on her testimony being sufficient. You should try to get an expert witness if you can to corroborate what she's saying, basically saying like, yes, this happens in that country, blah, blah, blah. You need detailed country conditions evidence. Do you have a witness of the actual events? If not, that's okay. Did she tell anyone that it happened? That's good too. Remember, the laws or the rules of evidence do not apply in any sort of strict way in either an affirmative or defensive context. So hearsay evidence is perfectly fine and it's great corroboration. So yes, like you definitely in this environment want to get as much corroboration as possible. There's also been some recent case law from the BIA about credibility. Immigration judges are very inclined to make negative credibility findings. I don't know if your case is affirmative or defensive, but you can sort of anticipate that by having corroboration to point to indicate that your client, yes, is telling the truth. Okay, you mentioned keeping the elements of the case separate from one another. What do you mean by that? Okay, so for any asylum case that you file, you must file a legal argument. So some advocates are in the practice of not filing a legal argument. So we have different terms for this, like memorandum, brief, case assessment. All of those are synonymous. The idea is you need to explain why your client is eligible for asylum. Best practice and just being like a semi-decent advocate is filing that with every case. You always should. So that's what I mean is like that's the place where you put together your argument for why all of these elements are satisfied. It can be very short. Short arguments can be very compelling, but you want to explain each element separately rather than just relying on your client's affidavit, for example, and assuming that your adjudicator will connect the dots through the affidavit or through the testimony. Any other questions on these first four elements here? Oh, and thanks, Vera. It's July 16th, components of an asylum filing. I guess that's next week. Good to know. Yeah, so that's where we'll be talking about what you actually assemble, and then also how you can prepare your client for adjudication in the interview or the trial. Okay, So moving on then to these next two, the last two bullet points here. So to succeed on an asylum case, you need to prove that the persecutor is the government or a private actor or group that the government cannot control. And then lastly, the threat of persecution has to be countrywide. So this last point is another way the government likes to ding asylum cases right now. They like to take the position that, okay, so you were persecuted in Port-au-Prince in Haiti, but the rest of the country is perfectly fine. Just move somewhere else. So that's why you need to prove that the threats are around the country, if at all possible, and not just isolated to a specific region or city. Okay, moving on to bars. So this is a pretty complex area of law, bars to asylum, but I'm going to give you just a snapshot of the really common ones that we've seen at a rise over the course of the last couple years. So the 1-year filing deadline. Generally speaking, applicants for asylum have to apply within 1 year of their most recent entry. But then we have these two categories of regulatory exceptions. So first we have changed circumstances, and I put the citation in here. So that's kind of what you would think it is. Change circumstances in the home country or in the individual situation or legally. So in the home country, that could be, say your client is from, let's just say, Venezuela, right? So our government, the US government's position is that Venezuela is better now, people can return there. Well, say that your client was a political activist and the group that was after her, that prompted her to leave years ago, is now revitalizing their threats against her because they know that the US is forcing people to go back there, right? That would be a changed circumstance in the home country, assuming it's coming from Venezuela. Changed circumstance in the individual situation could be something like social media threats, right? Anything that makes it riskier now or more recently for your client than during their first year after they entered the United States. And then legally is about, it's usually about loss of derivative status, like on another application, but it can be a legal change that makes them more in need of asylum protection than they were when they first entered. So that's changed circumstances. Extraordinary circumstances is quite different. It's a longer list. And it's important to note that the regulations say that the list that I provided here, and this is the full list that comes from the regulation, it's a non-exhaustive list, meaning that you could come up with other theoretical extraordinary circumstances that might comply with the regulation, that might qualify as an exception. So I rephrased all of the actual extraordinary circumstances from the reg. So serious illness or mental/physical disability. So the common one that we see is PTSD. So a symptom of PTSD is avoidance. Makes perfect sense. The traumas we experience as human beings, we want to avoid them. We don't want to think about or talk about them. So if it was PTSD that caused the client to not want to seek out legal help, for example, where they knew they'd have to relive everything, then that can be an extraordinary circumstance. As a mental disability is what it's called, according to the regulation. And then there's legal disability. So this is kind of related to what I was getting at with changed circumstances. Think about what makes the client legally vulnerable or what's been a legal change. So the example in the reg is UAC status. So that's unaccompanied alien child. So that's there's a whole bunch of statutory protections for UACs that exist for obvious reasons. These are kids who entered without any sort of like guardianship or protection or a parent. So if a kid has a UAC designation when they enter, they then are exempt from the 1-year filing deadline. Ineffective assistance of counsel. This has become super common. Lawyers are completely overwhelmed right now, so they might sit on a case for too long. Maybe they promised the client that they would file and then they forgot, or they, whatever. You can argue ineffective assistance of counsel, but there are hoops you need to hop through if you're going to pursue that kind of claim. Lawful status until a reasonable time before filing for asylum. We see that one a whole lot, especially now since TPS is being terminated for almost every single country. A lot of folks thought that they would be okay, and they were okay. They had status until they don't anymore. So ideally, you will file for those folks before the expiration of their status. You really don't want to get into that window because it's a very unclear window after their status expires. And then rejection of the application by the government. It's kind of funny that this is in there. This is in there because the government makes a lot of mistakes, and it's common enough that the regulation is providing for it. So the point here is that you need to document when you file an asylum application, either online or if you mail it, keep your receipts showing that you complied with that 1-year deadline. And if it's rejected, then of course you document that as well. So you can say like, no, this was timely filed. It was a government error that led to this problem. And then death or serious illness of a representative can also be an extraordinary circumstance. But remember to try to think creatively, like if there's a good legitimate reason why someone didn't file within a year, and you think it kind of fits the whole theme that we're seeing from this bulleted list here, make the argument if your client understands the risks, and if it's made in good faith, you should go for it. I'll pause. Questions? Oh, okay, I see one in the chat. I found a bunch of country conditions reports and news articles, but haven't been able to secure an expert as of yet. How much weight does, say, a website article carry, if any at all? Okay, so you need to put together a table of contents of your sources. I assume this is time sensitive because all these matters are. Shoot me an email and I'll send you a redacted sample so you can see what that looks like. Because you're going to need as many sources as, not necessarily as you can find, but you should have like at least 15, 20 sources to corroborate these issues. But just shoot me an email and I'll send that to you. Oh, I see one more. How long a client can have PTSD? Okay, so this is a good question about PTSD and the 1-year issue. So what you need to do, and you need to explain this to the practitioner that's evaluating your client, like the licensed mental health provider, there needs to be a nexus between the PTSD, the diagnosis, and the delay in filing. And it has to be filed within a reasonable amount of time after that nexus is established. So in other words, thinking about this practically, say, a licensed counselor says, yes, this person has bad PTSD. Avoidance is a very clear symptom of that PTSD. It was caused by the trauma they suffered in their country. That's why they waited 4 years to seek out an attorney. And this is still a problem. They're still avoiding because of the PTSD. You want to file your asylum case very shortly after you receive that report. So try to structure everything so that you can do that. That way, everything is clear that that nexus that the licensed provider documented is very clear, and then you file right after. Hopefully that makes sense with the timeline, because that's what you want to try to do. Does having a notario document prepare a case qualify as a... Okay, so it really depends, Matt. You can feel free to give more context there, but if the person... Okay, so there was a BIA case that was issued recently that is absolutely disgraceful. There is, long backstory. Matter of Lozada creates this framework that you have to prove if you're going to prove ineffective assistance of counsel for purposes of like reopening an immigration case. You have to file like with the authorities, the bar authorities, indicating that there was ineffective assistance of counsel, like file a bar complaint, jump through all these hoops. Very recently, the BIA published this decision that said, you know what, notarios don't qualify. They're not licensed. So this whole ineffective assistance of counsel thing, that like form of relief that comes through Lozada, that doesn't apply to notarios, which is disgraceful because then we just let notarios get away with it. And even though they wrecked the client's case, the client has no recourse. So I'm explaining that because unfortunately, when a client has been exploited and their case has been damaged by a notario, sometimes the options are more limited. But that doesn't mean you can't make the argument. You just have to be really careful because all kinds of other issues arise from this. Like you don't want your client to get dinged for misrepresentations or other issues because the notario lied. So if you're asking for purposes of the 1-year bar, I think that's a cognizable argument to say, like, yes, there's ineffective assistance of representation by this notario who did whatever they did. You just need to make sure that you cover your bases to right the wrongs, meaning like do a FOIA request, make sure you understand what was filed. Maybe you need to withdraw the application to prove to the government, like, hey, we don't even want this like in our client's file. We want to withdraw it to make sure that it can be filed properly. You get the picture. So I'm just flagging these issues for you because yes, it could be a theoretical argument you could make, but you could also be doing a lot of damage if you're not handling it properly. Do you need a formal diagnosis of PTSD? So no, you don't. I think that's the easiest one to argue based on experience, but it could be something else like say it's depression or some other formal diagnosis that you get from a licensed professional that caused the delay. What's important is the nexus. So ideally you would have a diagnosis. Obviously, this is out of our control. We're not licensed mental health professionals, but you need the nexus connecting the diagnosis to the reason or for the delay in filing, I'm sorry. So nexus between the medical or mental health issue and the delay in filing. It doesn't matter what the diagnosis is. It could be like migraines, right? That could qualify as a physical disability. You just need to make sure you're articulating it. Sorry, Matt, that's a really pessimistic answer. I just want to make sure I'm giving you a warning because of that new BIA case. Okay. Firm resettlement, another bar to asylum. Okay. So firm resettlement. It's a statutory bar to asylum, and then we have regulations that give us a little bit more information about what this means. So that's a common theme you see in immigration law. You have the statute that, of course, is terribly worded, kind of like the statute we read at the beginning of this, and then regulations give more detail about what the things actually mean. So it's 8 CFR 208.15 that gives some flesh to the firm resettlement bar. But just to make things even more confusing, if you look up 208.15 in the federal government's like book of regulations, it will show you a regulation that has been enjoined. It is not in effect right now. This is one of the reasons why immigration law is really confusing and challenging to research, is like you can't really find that injunction easily. And so, like I said, if you look on the federal government's webpage, the current version comes up. Don't go by that current version. It's not in effect. What is in effect is the regulation that was authored years ago and is still in effect because the new one can't go forward because of a court order. So the regulation that the Trump 1.0 administration tried to push through is extremely restrictive. This older regulation that actually is in effect now is much better and it's not as restrictive. So that's good. So what I did here is I put in a summary of the regulation, that is in effect now. Because if you look up the actual text, it's pretty confusing. So this is the summary of firm resettlement. So if after the flight from home country, the applicant entered into another country that is not the United States and received either permanent status or resettlement, they're barred from asylum. So that's what firm resettlement is. So say you have a client from Turkey, they head over to Spain and they hang out there for 2 months, but they have no status there. They're super transient. No one helps them out. And then they come to the US. I would argue they're not firmly resettled because they did not receive permanent status or resettlement. That was just one hop before they got here. Now, take the same situation and change it a little bit. Home country's Turkey, that's where they suffered persecution. They go to Spain. Spain's really kind, and they give them the equivalent of a green card. They live there for 3 years, have a lot of, joy and success in life, and then they come here, right? That would be firm resettlement, like very clear instance of firm resettlement. But then we have these two weird exceptions. So even if that second scenario that I just talked about that is like pretty clear firm resettlement, her entry into that country was a necessary consequence of her flight from persecution. She remained in that country only as long as was necessary to arrange onward travel, and she did not establish significant ties in that country. A very weird exception, because theoretically you could still argue like what I just said about the like green card equivalent in Spain. Maybe that was only like so that she could arrange onward travel. Weird things happen. Maybe you could make that argument. It sounds like wishy-washy, but maybe you could. And then the next exception, B here, is restrictions in the third country mean that she wasn't in fact resettled. So this is where like someone has limited rights in the third country, doesn't have equal access to legal protections, things like that. So these are very fact specific, but luckily the vast majority of our clients, they fall under, they do not fit like this broad category of having been the recipient of permanent status in that third country before coming here. Usually it's just a stop on the way. So that's firm resettlement. There's a lot of confusion about this because of what I explained about how like the current version of this rule is actually not in effect. It's been enjoined. Asylum officers get confused about this stuff a whole lot. So the onus is on us as advocates to make sure we're explaining like, no, this has been enjoined. This is the current version of the rule that's in effect now, that applies now. And this is why our client is not subject to the firm resettlement bar. So you can always be kind of aggressive in your argument. You can say, so no, she never received any sort of permanent status or resettlement. And also, she was very restricted in the country. That falls under that B category there. So you're getting to the heart of the regulation here by saying like, she had limited rights. She couldn't work lawfully. This was not any sort of like reasonable living environment for her. Also, she was only there because she wanted to come to the United States. And she was only there as long as she had to be before she could arrange onward travel. So you're sort of covering all of your bases to make sure that regardless of how they view the facts, she can't be fit into this firm resettlement bar. But the larger point here is to make sure that you're reminding the government of what the currently enforceable regulation is. Okay, I see another. Okay. Any questions on that? I know that's particularly confusing. Okay.
Jen,
Oh, yeah, go ahead.
I get confused between firm resettlement and then that they should have gone to another country. Like they went just because they went through, they should have stayed there.
You mean because our government just wants people to stay other places?
Right. And so I guess I don't know if that's safe third country or what they call that, but I thought there's something where they're just sending people because you don't even have an asylum claim because you should have stayed in that other country or you should have gone to another country.
Yes. So I think you're talking about the asylum cooperative agreements
Yeah.
and removals to third countries, many of which are very unsafe. So, yeah. So, what's tough is we can argue the legal requirements to the best of our ability so that firm resettlement doesn't apply. But yeah, the government's doing despicable things and removing really vulnerable people to very dangerous parts of the world. So, but that would be a different legal process. So, like for people in removal proceedings, a lot of advocates now are not only helping their clients articulate their fears of return to their own countries, but also to other theoretical countries in the world that the government here in the US might ship them off to, almost making like global asylum claims, you know? So, yeah, it's very confusing because these are sort of similar ideas, but the way that you argue against them, it's different procedurally. And because we only do affirmative asylum for the most part, we're just contained to these kind of arguments like the bars to asylum, statutory and regulatory. Whereas in the removal context right now, it's just absolutely absurd, to be honest. Like the novel approaches that these ICE attorneys are taking just to try to get people out to the third countries, like you were saying. Yeah. Okay. So procedure. This is just sort of just a practical thought for you. So it can be hard to know if someone is should apply for affirmative asylum or defensive. So affirmative asylum is for people who are not in removal proceedings. Everyone else, so people in removal proceedings, they have to apply before the immigration judge. So in other words, like immigration court, EOIR, those are all the same thing. Jurisdiction is interesting here, though, because jurisdiction has to vest with the immigration court in order for the case to proceed before the immigration judge. So I'll give you an example to illustrate what I'm talking about. A lot of people cross the southern border, and this has been happening for many years. They're handed an NTA, so a notice to appear. That's the charging document for that is filed with the immigration court and served on the client. They're just handed an NTA, but it's never filed with the court. If it's not filed with the court, jurisdiction has not vested with the immigration court. And that means that that person can generally apply for affirmative asylum with USCIS. How can you tell if this happened, if an NTA was filed or not? Because maybe your client hands you an NTA, but they have no idea if it was actually filed. They haven't gotten a hearing notice or anything like that. You can call the EOIR 1-800 number, punch in the A number, which would be on the NTA. You can also use the new EOIR portal. Same idea. You punch in the A number and the country of origin, and you can see if there's a pending case. Those two options aren't always reliable. I would say in my experience, they're like 95% reliable. And then, of course, you can FOIA to get the record to see if there is an active case in front of the immigration court. And if not, then you would file affirmatively. I'll pause there because there might be questions. Okay. And this was what I was talking about earlier, and we'll talk about it more in depth next week when we chat about the cases and the components of an asylum case. So this is everything that you're going to file when you apply for asylum. And generally, you do not want to just submit an I-589, the application for asylum. You want to submit everything at once if you can. Sometimes there's cases where your client drags their feet, the deadline is approaching, you need to do what you need to do, but it's definitely best practice to get everything in all at once. There's a ton of reasons for that. One being that clients can interview very fast. So you might not have any time to supplement the record. lots of reasons for it. But I'll just go through quickly the different components. So the affidavit is the client's story. Evidence is super broad. You're trying to corroborate as much as possible, explain the situation in country, get witness affidavits if you can, take pictures of scarring from persecution, all that kind of stuff. Country conditions evidence, that's what I mentioned earlier. We put together a table of contents that's annotated of all the country sources that we have. And the brief or the legal argument is just a written out explanation of why your client is eligible for asylum, why any potential bars don't apply, why your client is deserving of a favorable exercise of discretion. And then there's the actual application, which is pretty robust. It takes several hours to complete usually. And then there's the interview preparation, because clients generally need a lot of help understanding what's relevant and what's not relevant to talk about. And again, we'll go over that in more detail next week. Okay, comments, questions? Nope. Okay. Oh, I'll put my email in the chat. Thank you. Okay, yeah, my email's in the chat if you want the slides or certificate of attendance. Or I think it was the gentleman who mentioned notario fraud. You can feel free to follow up with me about that too. I'm sorry you're dealing with that. That's really horrible. Okay, I think I got through all the questions in the chat. Okay. Well, thanks everyone. Thanks for coming and for listening and for caring about these important issues. And I'll send out a reminder for next week's discussion as well. Have a great night. Thanks everyone.
Thank you.
Bye.